should you charge royalties when licensing your creative works? Imagine turning your creative ideas into a steady income stream. That's what licensing your work can do, but should you charge royalties for every use? Let's find out. When you create something like art, music, software, or a brand name, copyright law protects your rights. It gives you control over how your work is used. Licensing is a legal agreement where you allow others to use your work under specific rules. Usually, you set a fee for this, which is often called a royalty. Charging royalties makes sense because it lets you earn money every time your work is used or sold. If a publisher prints your book or a company uses your logo, you get paid based on sales or usage. This creates a continuous income, not just a one-time payment. Royalties also motivate licensees to promote your work well. If they make more money from your work, they're more likely to respect your rights and follow your rules. Plus, licensing lets you keep control over how your work is used, especially if you include quality standards or branding rules in the agreement. There are different types of licensing agreements. An exclusive license means only one licensee can use your work in a certain area or for a certain time. These usually come with higher royalties because the licensee has sole rights. Non-exclusive licenses let multiple people use your work, often with lower royalties but more widespread use. You might also charge an upfront fee when signing the license, along with ongoing royalties. Sometimes, you set a minimum amount you will earn regardless of sales, which helps protect your income. For example, you might agree on a 10% royalty rate on all sales or a fixed fee per unit sold. When licensing trademarks, like logos or brand names, royalties are common because they reflected the value of your brand. You want to make sure licensees follow your quality standards so your brand remains strong. Royalties help justify your investment in maintaining the brand's reputation. If your work involves patented inventions, licensing with royalties is standard practice. You'll specify how the patent can be used and how much you will earn from each licensee. This ensures you are compensated for the exclusive rights you grant. Many creators of art, software, or branded content license their work to publishers, manufacturers, or distributors. These agreements should clearly spell out the royalty rates, payment schedules, and what happens if someone infringes on your rights. Consulting an intellectual property lawyer can help you craft a fair and effective licensing deal. In the end, charging royalties when licensing your creative works is a common and smart way to make money from your ideas. It lets you earn ongoing income while keeping control over how your work is used. This approach aligns with the principles of copyright, trademark, and patent law, which focus on protecting and making the most of your intellectual property.